Let's jump to it now. Talk to our guest. He is the proprietor of a great website, a really invaluable resource called combatsportslaw.com. He is an attorney in the Great White North. Erik Magraken returns to the show. Erik, how are you?
I'm good, Luke. Thanks for having me on again.
I am happy to speak to you. How is you're in Vancouver? You're in the west side of Canada?
Yeah, close to a little town called Victoria, which is on Vancouver Island, just about as far west as you can get in Canada.
What is the weather like in Victoria today?
Well, right now it's beautiful. We talk in Celsius up here, so it's about 18 Celsius. I can't remember what that translates to in Fahrenheit, but probably high 60s, sunny, crisp, beautiful. 65
degrees is what that would be.
Yeah, that's probably.
That's pretty nice. All right. Sounds pretty good. Well, happy to have you back on the show. There was just a few, what do you want to say, legal-related issues in MMA, legal issues, not legal-related, that I thought you always have really smart, informative takes on. I kind of wanted to sort of put them all together if we could. And I wanted to start with this Bisping one. Now, I saw that you had tweeted about it earlier. You've written about it. For folks who may not have seen, Michael Bisping was sued, and correct me if I'm wrong, Erik, he was sued by a teenager. Can you tell the listeners what he was sued and what this person is claiming? Why he was sued, excuse me.
Sure. So the incident apparently back in the summer, I think around July, this plaintiff alleges that Michael Bisping assaulted him in a gym. So there's some kind of interaction between the two of them. And the legal grounds for the lawsuit are numerous. I'm holding the complaint here. Bisping's being sued for battery, assault, false imprisonment, intentional infliction of emotional distress, and then the gym that this occurred in and the UFC and their owners are all brought into this lawsuit as well under various other legal theories. So it all sounds pretty serious when you look at it, but when you read the substance of the complaint, it doesn't leave me with the impression that anything too serious actually occurred between the two of them, but I guess time will tell and tease out those facts.
If it's as serious as this person alleges, why was Bisping not arrested? It sounds like what he did, according to the complaint, was commit a crime.
Yeah, I'll have to speculate here, but my guess is the police came, looked at the video, and that the video was far from impressive in terms of, the nature of what was depicted, and they decided to leave well enough alone or let this play out through the civil process. But I sue people for a living. That's my day job. I'm a personal injury lawyer, and so when you put together pleadings alleging what the injuries are, they tend to be pretty comprehensive. But here, if you take a look at this lawsuit, the physical injury, there's not even really a diagnosed injury in this lawsuit. It just says, just trying to find the language here, the plaintiff alleges that this assault caused, quote, intense throat pain, end quote. Okay, and then everything else that's listed is basically psychological in nature. So it just doesn't leave me with the impression that there was any kind of a serious injury here. But again, I think somebody's going to get their hands on the surveillance sooner rather than later, and I imagine that's going to make the rounds on the internet, and judgment will flow from there.
Assuming this gets thrown out, which it sounds like it could, nevertheless, this will cost Michael Bisping some money. How much would it cost Michael Bisping, reasonably speaking, to defend himself even against a lawsuit like this that could be frivolous and dismissed rather quickly?
Well, lawyers are expensive, as you know. I couldn't guess what he'd end up paying there in legal fees. But I'll tell you this: in terms of the case getting dismissed, if what is alleged did happen, there's probably some liability, but it's modest liability. The law is very easy for plaintiffs in cases of assault and battery. The law basically sets a very low threshold. If you touch somebody intentionally without their consent, that's a battery, and that's enough to sue. But without there being a real serious injury there, what you get from that lawsuit is a token award, basically a slap on the wrist saying, okay, you shouldn't go around pushing or shoving or grabbing people by the throat. But unless you're really injured, it's not worth much of anything. And again, I don't want to assume that this man's injuries are trivial. I just have that impression from reading the court filing. But anybody who's in a lawsuit as a defendant, that's the business decision they have to make. How much is it going to cost to defend this thing versus how much could I pay by way of a quick settlement just to be done with the time and expense of the lawsuit? And Bisping's probably going to have to ask himself that. But if you look at it, the fitness gym was sued, the UFC, and I'm saying that correctly, the UFC was sued. Those three letters were sued. That's not even a legal entity that can be sued. And then the UFC's owners were sued as well. I think all of those entities are going to fight this lawsuit. I don't think they're going to pay any kind of a token settlement here. But my impression is if somebody is liable, it'd be Bisping and Bisping alone, and depending on the severity of any provable injury, that's where the dollars could come from.
So that takes me now to Mark Hunt, and again, we're joined by Erik Magraken of CombatSportsLaw.com. Now, there's not been a ton of legal updates from what we know, but this is kind of what I wanted to pick your brain about. He was on that UFC Sydney card. He was ostensibly, or at least reportedly anyway, removed because of comments he had made about cognitive impairment in an article. They removed him from it. He has now updated, not the article, but written another article, by the way, with his byline on both, which creates a weird level of responsibility he doesn't seem to want to own up to. And this time he's saying, yeah, I mean, look, I might have gotten a little bit older, but I'm still, whatever cognitive impairment I've suffered, it's not below a certain threshold that should prevent me from competing. And people around him have even reached out to me to say, we have good reason to believe this is some kind of legal retaliation. But I'm not saying that's not true, Erik, but I don't know legally how would this be retaliation? I can understand this would be professional retaliation, but it doesn't serve their interests either. Fabrizio's not going to do the job for them in Sydney that Mark Hunt would.
Yeah, his comments in that first article were troubling, and it puts the UFC in a really tough spot. And I know they've got a strained relationship with Mark Hunt with the ongoing litigation from the Brock Lesnar fiasco there, but I'm not sure that it's retaliation either. Perhaps it is. I can't speak for the UFC, but when you read one of your fighters, and I think he's the oldest fighter on the roster, and he's been through many, many wars, both in MMA and kickboxing before that, when he's complaining about these cognitive symptoms which are consistent with CTE, and again, I'm not going to diagnose him with CTE, but it's at least consistent with the early signs of long-term brain trauma, the promoter's put in a tough spot about whether you want to keep using this guy. Now, what the UFC can't do is pull him and sideline him indefinitely, not offer him any more fights, and not release him from the contract. I think they're going to have to pay attention to whether they want to release Mark and let him go fight for others if that's his wish. I think that's the tough choice they have to make there. But from Mark Hunt's perspective, the one thing he says that has merit is if you're going to sideline people based on social media comments, why is he the only one that's been targeted like this? Other fighters have made concerning complaints over the years, and I don't think the UFC has pulled them from fights. And so if there's an internal policy where the UFC wants to get into the business of determining who's had too much mileage to fight, I think they have to start doing that across the board. They can't just target Mark Hunt, and maybe that's why Mark Hunt feels that it's retaliation, since he's the standalone example. But even with that being said, Mark's people say like GSP and aliens and stuff like that. Mark Hunt's complaints were very specific, and as you point out, it was in the first person. It wasn't somebody attributing words to him. He himself said he's forgetful and has these headaches and other things consistent with a career full of mileage. So I think he's created a tough spot for himself.
You also have reported on CombatSportsLaw.com about UFC fighter Lyman Good suing for a tainted supplement against the manufacturer who made it. This is relatively not relatively. This is very uncommon in MMA. Less so uncommon as I did some research, Erik, in, let's say, NFL football. There's been a number of athletes who have sued. What is Lyman Good claiming here? What reasonably can he do with this lawsuit besides ostensibly claim damages?
Well, at quick glance, it looks like there's substance to the allegation. What he's saying is he bought an over-the-counter supplement, and it listed what's in there, and they had substances that were in there that weren't listed. And if you're selling something to the public and not disclosing what's in there, and you know that your audience, your purchasers consists of athletes, some of these people are going to be subject to drug testing, and here's the fallout, right? He gets pulled from the upcoming UFC card. He's sidelined for a while. He's out earnings. His reputation takes a hit. So I think he's got a legitimate grievance here.
Now, The sad part, though, is, again, I don't know how much you've looked into this. My reading of the previous times this has happened is in a number of cases, the plaintiff will win, but by that time, I call them shell companies, not in the traditional definition, but only to say that they barely exist at all. There's nothing really to them. So then when they face any kind of lawsuit like this, they crumble, and there's really no assets to claim after that.
Yeah, there's the tough part of it. Having a claim that has merit and succeeds is one thing, collecting is another, but part of it's PR as well, right? Like, good for Lyman, even if he ends up getting a dry judgment where he wins, he's exonerated in court, and that goes a long way to restoring his reputation, because these stories tend to gather headlines. But if the defendant he's suing has no assets or goes bankrupt or otherwise is protected from the fruits of litigation, that's really unfortunate for him if that's the outcome.
So then let me end on this one, the Kevin Lee story. This one has been, you've done an excellent coverage for this as well. It's been an incredible story. He fought with staph, he admitted it, and how it got there is kind of crazy. What is the latest on the Kevin Lee story? Tell the listeners, if you can, that he essentially lied on a pre-fight questionnaire. Why is that a problem, and what could happen?
Sure. So these pre-fight medical questionnaires, his bout was in Nevada. I think it was UFC 216. And the issue here is Nevada uses a pre-bout medical questionnaire fighters have to fill out. It asks them a host of questions. There's about 15, 20 questions there. But the answers are made under penalty of perjury. So this is basically something you're telling under oath to the Nevada Commission, and they asked him about whether he had any illnesses or disease, and he says no. They asked him about whether he was taking any medication whatsoever in the 30 days before the bout, and he says no. And I think he went on Ariel Helwani's show after the bout and said he used makeup or something like that to cover up this otherwise visible staph infection. And so, what he could be facing is repercussions from the commission for him not being honest with them on that questionnaire. That questionnaire is the hammer that the Nevada Commission uses against fighters when they're caught doping, and then they pull out the old tainted supplement defense, right? They pop for a substance and they trace it back to whatever tainted supplement or whatever explanation they come up with, and the commission says, look, you told us here under oath you weren't taking any supplements, you didn't identify anything. And so the commission's used that form to hammer folks before. Now, what I don't know is this. If I recall, I think it was either you or Mark Raimondi reached out to the Nevada Commission after that bout, and they said Lee was cleared by a couple of their doctors. Mm-hmm. So what I don't know is if the commission knew about the staph infection before the bout and let him compete anyways. And if that occurred, I don't expect Nevada to do anything, because even though they were lied to, they found out before the bout took place, and they probably don't want another spotlight being shown on that fight. But if he did hide it from the commission all the way through the bout and they didn't know until afterwards, I'd be surprised if they don't take action against him.
Well, it was definitely Mark Raimondi, because the Nevada Athletic Commission stopped returning my emails years ago. Let me assure you about that. Very quickly, though, I mean, you've reported on this as well, there are a narrow set of conditions under which someone actually can compete with staph. It usually involves them being on antibiotics for a defined period of time prior to the contest, which I don't think he was, and even if he was, he certainly didn't disclose any of this.
Yeah, well, he certainly denied taking antibiotics on that form, and again, I could be corrected here, but if I recall correctly, it was either him or somebody associated with him gave an interview stating he was on antibiotics prior to that bout. So I reached out to Nevada about any policies they have about fighting with staph, but they didn't get back to me with an answer to that question. So I then reached out to the Association of Ringside Physicians, and interestingly, the ARP themselves don't have a written policy about fighting with staph, but Dr. Ray Munsell got back to me, and he said they by and large would follow the NCAA and USA Wrestling guidelines for competing with staph. And what those say is if you've been on oral antibiotics for at least 10 days, and let me just pull it up here so I can get it right. And in addition to that, there's no new lesions during those 10 days, and there's no active draining lesions for at least 10 days prior to the competition, then it's okay to proceed. So I don't know. I didn't examine Lee. I don't know if he had a draining lesion or not within those 10 days, but he very well may not have met the NCAA standards to fight. And what I think was most concerning about the whole ordeal is that he was allowed to continue his fairly significant weight cut.
Right.
Being on antibiotics, missing weight the first time, and he was making a big cut. I can't remember the number. But
19 pounds.
19 pounds. So, it's not a record-setting cut, but it's on the heroic side of the cuts these guys make. So having staph, being on the antibiotics, missing weight, and then somehow being cleared to go on and dehydrate more just doesn't gel with the impression of a commission taking weight cutting seriously. I was actually really surprised that bout was allowed to continue.
I guess we'll have to see if he faces any repercussions and what this all tells us. It just sort of makes me curious about how thorough any kind of pre-fight exam is on fight week. If you can put up makeup and then lie on a questionnaire, that's enough to get by these doctors. If you're not honest with your doctor, they can't treat you, right? If you go to the doctor and you say nothing's wrong and, you're coughing up blood, they can't fix that problem. But at the same time, if you're you have to take that examination in a way where you have to imagine there's a degree of duplicity on the part of the fighter. It just makes me very curious about how thorough these exams are. You know what I mean?
Yeah, and so I'm a pain in the ass. I went and I made a public records request to Nevada, and I asked for all of the information the physicians gathered about this physical when he was cleared for more weight cutting. And the physician's report came in. He had a sitting pulse of 134, and he had a standing pulse of 152. And if you compare that to every other fighter on the card, he's basically double. So he's sitting there with a pulse double of what everybody else has. And that's the information the doctors have when they allow him to keep fighting. At least I'm presuming that. And I'm presuming that because my request to Nevada was give me the doctor's records when they cleared this man to continue cutting. And this is the information they gave me. So if that's the case, I'm not sure what it is that the doctors are looking for to actually pull the guy from a further weight cut, because that, to me, that seems about as bad as it gets.
That's insane. You do great work, Erik. You can read more of Erik's work at Combat Sports.